Morning.
Good morning.
Good morning.
Good morning.
I have down this morning. I really honestly was not sure who was going to appear because I got a flurry of emails from people saying they had withdrawn from the case. And so I was starting to wonder who was left. But what I have is a matter that is on for a status hearing in PS Customs Brokerage Inc. and Falcone Capital Holdings versus Patricia Duffy. This is a case from back in 2018. Of course, I'm telling all of you things that you already know, but for my own benefit to sort of get grounded in what is going on with the case. My understanding is that Ms. Duffy, who was the defendant in the case, ultimately filed bankruptcy, and that that bankruptcy has now essentially resolved, but someone will educate me about that. And that the question is whether or not this litigation, I understand the question is whether it was resolved by the bankruptcy or released by the bankruptcy, and how and in what form it currently still exists and needs to go forward or not go forward. That's what I understand to be the issues, and I welcome anyone who is able to update me and educate me about the actual status of the case. I see that I have Miss Duffy on the call, starting with, say, Ms. Lazzaroni, just because you're in my top left of my screen. Can you tell me who you represent in this matter?
Yes, ma'am. I represent Anon Stillman and the law firm of Stillman and Welch. They
Okay,
were added to the lawsuit by a counterclaim asserted by Miss Duffy in
right.
response to the action you mentioned. Um, I can tell you a little bit about the case, or do you want to meet everyone
I just
first?
want to meet everyone first, and then I'm probably going to come back to you as well. Miss Gilmore, who do you represent?
Good morning, Your Honor. Martin Cave and I represent counter defendants, Falcone Capital Holdings LLC, John Falcone, and PS Customs Brokerage Incorporated.
Okay, and Miss Holloway, how about you?
I think I was noticed by accident because I have no part in this case.
Oh my
Um,
goodness. Now, is
but
it something that
whenever
you
I get a
previously?
notice, I show up.
Well, I tell you, Miss Holloway, that's better than some lawyers. Some lawyers get notice in cases they are involved in and still don't show up. Um,
So,
Mr. Freehoff, if you'll check our records and figure out why it is that Miss Holloway was noticed. Miss Holloway, do you not recall having any connection to this matter, or is it maybe Mr. Freehoff, we had another case that was on the calendar that got canceled?
it may have been another case that I think you've already said you're going to sign an order on it, but I
Okay.
don't have nothing to do with this case.
Okay, excellent. Well,
Yeah.
then congratulations, Miss Holloway. You get to jump right off.
Okay, thank you. Have a
Thank
great
you, Miss Holloway.
day.
Have a good day.
Okay, bye.
Okay, so I'm going to go back now to Miss Lazzaroni, and if you could sort of, am I pronouncing that correctly?
You are. You
Okay,
are.
excellent. Also, I have to say, um, I don't know if any of y'all are familiar with the Bechdel test, but it's not that common that I have hearings where it's just all women. It's kind of
Awesome.
fun. Miss Lazzaroni, if you want to educate me about this
Sure.
matter.
Sure. Prior to Miss Duffy's bankruptcy, we had litigated this case for almost over a year. We had three discovery extensions, two consent schedule orders in place. And prior to the third scheduling order, which also had Dalberts and MSJs and a trial calendar listed in it, the month before, Miss Duffy filed bankruptcy, and that stayed everything. The trustee took over the case and assigned counsel to pursue the case in 2021. In 2024, Mr. Lang filed something with the court saying, hey, we're going forward in the Superior Court. We would like to reactivate this case. I don't know why it took 3 years for that to happen.
I was curious about that as well. I think somebody in the case reached out to us within the last month or two, and only then did we realize that a motion to reactivate the case had been filed that no one had ever provided us with. And just so you know, you probably do, but filing something in Odyssey doesn't give us notice of it, because you can imagine what my inbox and my staff attorney's inbox would look like if he got a notice of everything that was filed in every one of our cases. And so we never received the request to reactivate the case until I think somebody brought it to our attention in the last, maybe within the last month. And that's why we put it on the calendar for a reactivation. And then everybody started dropping out of the case, or at least the lawyers started dropping out of the case.
They did. So I am not involved in the bankruptcy part of it, but we understand that the trustee decided to abandon this claim as part of the estate, and she served notice of that. Simultaneously, Mr. Lang moved to withdraw, and that's why Ms. Duffy's here now by herself.
Okay.
But in the time period that the trustee decided, this is my case and I'm going forward and I've hired a lawyer and get moving on it, that 4-year period, nothing happened. Nobody asked for a discovery. No one did anything. So this case is basically where we left it in 2019. So that would be a month of discovery left and MSJs, and quite honestly, a lot.
So one, from a procedural or structural standpoint, I certainly understand the authority and the ability of the trustee to abandon the counterclaim that was raised by Ms. Duffy. But I don't think that the trustee would have the same authority as to the claim against Ms. Duffy that originally initiated this action. Can somebody provide me with confirmation or insight that the underlying direct action against Ms. Duffy, perhaps Ms. Gilmore, since I think you said you represent one of those original plaintiffs, that claim necessarily must have been resolved if it is a debt potentially of Ms. Duffy, correct, Ms. Gilmore, or does your client take a different position on that?
Your Honor, I'm actually not sure about that. I tried to check the bankruptcy filings yesterday, and I'm unclear on that particular issue. I'm trying to see if I can get additional guidance right now. And in addition,
was it in the Northern District of Georgia, I assume?
yeah,
Do you know who the judge was?
Craig.
I'm sorry?
Craig.
Judge Craig. Okay, thank you.
Your Honor, and my clients also have, I believe, personal counsel is still involved in this case as well.
Okay. Thank you, Ms. Gilmore. Ms. Duffy,
Yes.
you don't have an attorney, which is unfortunate currently. I'm sure you're aware, Mr. Lang, who I believe had been assigned essentially by the trustee, or at least authorized if you had some involvement in choosing him as counsel. He either had been appointed by or authorized by the bankruptcy court to pursue this claim on your behalf, and then the trustee decided not to pursue it, and then Mr. Lang removed himself from the case. Do you intend to pursue the counterclaim, and do you intend to retain counsel to do that?
Okay. Sorry. Good morning, Your Honor. My name is Patricia Duffy. And basically, I just found out about this hearing from my bankruptcy attorney as of 3 days ago. So all of this has just came about.
Well, in defense of that person, I think that the official notice was only about 7 days ago. So,
Right.
So everybody it's a fairly short notice hearing, but go ahead, Ms. Duffy.
Exactly. And of course, I got my copy by snail mail. So I spoke to my bankruptcy attorney. I was aware that Tamara Ogier, my trustee in the bankruptcy, abandoned the case as counsel. And subsequently, Mr. Lang also has abandoned his interest in the claim. And now it is in my lap to decide what I wanted to do. And I spoke to my attorney, and her and I discussed this, and I would like to have additional time, please, to retain a new attorney to represent me in this case, as I have no counsel and I do not plan on dropping my claim. Like Ms. Lazzaroni stated, there was nothing that happened for years, and I was not able to know this. So I just waited for notice, which is now. So I'm asking, please, for additional time to retain counsel.
Okay. Couple of questions, Ms. Duffy, and if you don't know the answer, that's fine, I understand. But so obviously, typically when someone files bankruptcy, one of the benefits that is afforded through the bankruptcy process, assuming it's all orderly followed, is satisfaction or negotiation and resolution of claims against the debtor. And this lawsuit started as a claim against you, and presumably would have been listed as a claim in the bankruptcy, and it would have been the obligation of the trustee to litigate or figure out what to do with that claim. Do you know anything? I understand you and or others asserted, cross claims, counterclaims, third party claims in this case, that it sounds as if you do not wish um, to abandon at this time. But I guess my question is, do you know what the status is of the underlying original claim by the two plaintiffs against you that was originally filed in this case, which is where your counterclaim arose?
Yes. Originally, when Mr. Falcone filed claim against me, immediately we filed counterclaim. My claim, Mr. Falcone's claim against me was, I have in writing that it was his charges against me or claims were dismissed. Then this left my case against Mr. Falcone, PS Customs Brokerage, however it's listed, this case number. So I declared bankruptcy, and it was my understanding at the meeting of the creditors, which we were all present, that Tamara Ogier, after this, Tamara Ogier took my case on as a case she was going to prosecute and go after for an asset. So in my bankruptcy, this case was listed as an asset of mine. The trustee, under my understanding, is supposed to go after any assets possibly that you have in order to pay off any of your creditors. Okay. So she took the case on. I was not aware anything, what happened after that point.
Mm-hmm.
So, but that's where we are, is my claims, like Ms. Lazzaroni stated, I was in the middle of depositions and everything stopped.
Okay. So the only part I'm not quite following, Ms. Duffy, and I don't know if maybe Ms. Lazzaroni or Ms. Gilmore can give me some insight here. And I don't know what's happening with my camera. I apologize for that weird
Okay.
lack of focus thing. I think I understood Ms. Duffy to be saying that she believed that even prior to the time of her filing bankruptcy, that the underlying claim had been dismissed. And I don't see any record of that in the docket. And so I'm wondering if perhaps Ms. Duffy's understanding of that might be mistaken, or maybe that if that occurred at all, that it might have occurred as part of the bankruptcy. Because certainly they would have had to have been listed as a potential creditor of the estate, given that they had a claim. Do either of you have any further insight on that, Ms. Lazzaroni or Ms. Gilmore?
So, Your Honor, Ms. Lazzaroni, it was not dismissed in your action.
Okay.
So what happened in the bankruptcy, my client was not attached to that claim. So
Okay.
I don't know what happened to it. And if it was discharged, there should be some documentation showing
Mhm.
what was discharged.
Okay. Ms. Gilmore?
Your Honor, we have a notice of abandonment, but I don't have a notice of discharge. So the notice of abandonment was filed in the bankruptcy on December 12th of 2025. And in that particular claim, the trustee abandoned the Falcone counterclaim, believing that it was burdensome and of little or no value to the estate. So I don't see that it was discharged, but it was abandoned. And I do think those are two, I'm not sure if they're two different things. I don't do bankruptcy law, so I'm not sure about that.
Yeah, none of us do. I think we all just know the bankruptcy stay is the big, 800-pound elephant that stops everything. I know just enough to probably be dangerous. And basically, the one thing I know is that the trustee had to have had some understanding of the underlying original claim in order to abandon the counterclaim. And that's what I think we need the answer to. And I think that perhaps in the time that it will take us to try and get an answer to that question, Ms. Duffy might have some time to see about retaining counsel. I mean, the funny part is this case is so old that I wasn't even a judge, much less the assigned judge when this case was stayed for bankruptcy in 2018. And so it is, I mean, my records indicate that this matter was stayed in 2019 when I was the judge at that point, but everything before that had been discovery actions by the parties, and that the last order that was entered by the court was back in, there was a scheduling order that was entered and some pending motions that were ruled on by the court, but that was my predecessor. So I think all of us need some time to get our hands wrapped around this. What I will likely do is have two things. What I'll probably do is enter an order, sort of resetting another status conference for about a month. At which point I'll be looking for Ms. Duffy to have retained counsel and have someone have appeared on her behalf. And two, I'm probably going to reach out to the bankruptcy trustee and ask her for some kind of report, some kind of update to the court regarding the status of, I think that the notice of abandonment clearly provides the trustee's understanding and dismissal or abandonment of the counterclaim that Ms. Duffy raised in this action. What I think is clear is that Ms. Duffy has an understanding of what maybe happened to the underlying claim, but that Ms. Lazzaroni, Ms. Gilmore, and I are not clear on what happened to the original underlying claim. And I suspect that if that claim had been discharged, that it would have been referenced by the bankruptcy trustee. I suspect that, but I also am somewhat surprised that the status of the underlying claim was not referenced in some way in what was provided to us by Mr. Lang and by the bankruptcy trustee. But I think my intention is to have my staff attorney reach out to the bankruptcy trustee and ask for some update about what is the status of the underlying claim, at least as she understands it, so that we can figure out what to do. And hopefully in that time frame, once we have that information from the trustee and then Ms. Duffy would have time to retain counsel, then the parties can figure out what to do with the case. I mean, obviously we all know that the longer a case sits, the harder it is to, memories fade and, get everybody where they need to be and make sure you can take depositions of all the players. So, once you guys are able to put some attention to it in the next 30 days, perhaps y'all can discuss, what is the positioning of the parties, because obviously I need to know. I mean, I understand, Ms. Lazzaroni, your client really doesn't have a dog in the bankruptcy fight, but whether and the extent to which those claims still exist might affect the litigation. And Ms. Gilmore, I think certainly, I would think your client would have a vested interest in understanding what the bankruptcy judges or trustees' position is on whether the underlying claim that they originally brought has been discharged or continues to exist as a potential debt that Ms. Duffy owes? And if so, why was it not litigated in the bankruptcy action? Okay. Any questions for me or concerns about that plan? Ms. Lazzaroni?
Yes, Your Honor. So this case, has been pending since 2018, and it is a burden for my client. We would like to get it off of our books. They would like to get it off of their books. So I understand there's some confusion you need to deal with, but we would ask that at the next status conference, you consider dismissing this case for want of prosecution if it doesn't have everything lined up and ready to go at that point of time. Or set a very short scheduling order that allows us to brief it and get the motions heard and move it to trial, because it's just been languishing. Now we're approaching almost 10 years, which is a lot. And it needs to be dealt with. We also have no way of reaching Miss Duffy. I know she's got late notice and she was fortunate enough to appear here this morning, but we have no contact information from her. So if I want to send her something or communicate with her even through the court system, I don't know how to do that.
Ms. Duffy, I understand that it's your intention to retain counsel, but in the interim, typically one of the things my staff attorney will ask is if you have an email address that we can use to send you notices, and that way you would get notices from us by email through our automated system rather than by snail mail. Do you have an email address that you can share with the court, and that, of course, based on Ms. Lazzaroni's request, that they would use as well?
Absolutely.
Okay.
Absolutely. It is all lowercase, Patty, P-H-E-T-Y, Duffy, D-U-F-F-Y, 103 @gmail.com.
Okay.
My address is
Well,
315.
I think, forgive me,
Oh.
we are technically this is on the internet, so I don't necessarily want you to share your physical address, but I
Okay,
know we have it because we provided you with physical mailing of your the notice for this hearing. And if council needs it, they can reach out to Mr. Freehoff, or they can email you and you can provide them with that information.
okay,
I do think, Ms. Duffy, that to the extent that you are talking to attorneys, you should let them know. I can't give you legal advice, but you should let them know that this case is very old, and that there are at least some parties that are seeking dismissal of the case. I think that's fair to make sure that any attorney that might be thinking about getting involved in the case.
right,
I would also, Ms. Lazzaroni, the reason I mentioned that to Ms. Duffy is I do agree with you that there is, I think there probably is some motion practice that would need to occur at the outset of the restart of the case, so that we can figure out what claims are still pending and what are not. And frankly, that's why I want to find out what the status is, because I mean, there is a universe in which not just your client, but Ms. Gilmore's client, Mr. Falcone, could be moving to dismiss the counterclaim, or that Ms. Duffy could be moving to dismiss the underlying claim, all because of the effect of the bankruptcy. And that is something that the court doesn't really know. And that's why that status conference, to the extent that we get some information, I may reach out to the parties and let you know, hey, you should be prepared to discuss these topics at the status conference, assuming that we have substantive information from the bankruptcy trustee by that point. Ms. Gilmore, anything else from you? Questions, concerns about that plan?
No, Your Honor, I think that's fair. I mean, we would certainly agree with all the points that Ms. Lazzaroni made, but understanding that we're going to have another conference in about a month, I completely agree with what the court
Okay.
are.
Excellent. And Ms. Duffy, just so you understand, and I'm not saying that this is your plan, but sometimes I have pro se litigants who they say, I'd like more time to get counsel. And then they come back 30 days and say, I'd like more time to get counsel. I'd like more time to get counsel. And that's not going to work, right? I mean, I don't want you to represent yourself. That's generally not a great idea. But at some point, if you come back in 30 days and haven't retained counsel, I'm going to expect you to tell me all of the steps you've taken to retain counsel so that I can understand that you're making good faith efforts to find counsel. Otherwise, I will assume that you wish to proceed on your own without counsel. So I just want to make sure you understand that this 30 days it's a pretty tight window if you really are going to retain counsel and get someone on board. Okay.
I totally understand.
Okay. Well, thank you all very much, ladies, for walking through this process with me and helping me understand a little bit better about the status. I'm going to follow up with Mr. Freehoff. Actually, if you'll stay on the Zoom when we get off, when the hearing is over, Mr. Freehoff, we will take steps to reach out to the trustee, and then we will schedule and notice another status conference in February.